Welcome to the CITIcares Small Business Academy, presented by Citi Trends and the law firm of Seyfarth Shaw. In this 6-episode series, we explore what it takes to start a successful business designing or manufacturing products for retail sale. Welcome to the 4th session in the 2021 CITIcares Small Business Academy. The company you keep, entity, formation, and contracts. Our presenters today are Roger Best of the law firm Seyfarth Shaw and Michael Buchsbaum of Citi Trends.
Hi, my name is Roger Best, and I'm an attorney with Seyfarth Shaw, and I practice commercial and corporate law. And we're going to be talking today about entities, meaning corporations, partnerships, LLCs, etc. First of all, I should mention that every business is unique. And what we're going to be talking about today are really a discussion of the characteristics of various entities and how those entities can be used to benefit any business, not your business in particular. The factors that need to be considered in determining what is right for your business include a whole host of issues, including, for example, what type of business you're in, what industry you're in, the parties involved, the roles of each party, the tax regimes of the owners, and the funding plans that you have for the business. In fact, for example, if you're going to be raising capital, where are you going to be raising that capital fund? If it's debt, is it equity? Those sorts of considerations. And the management and control of your company. And so these are just some of the considerations that need to be made in deciding what sort of entity structure you should be using. And again, this is something you'll be talking about with your professional advisors. So let's set the stage here. Why should you care about entities at all? Your expertise is in making apps, for example, or baking cakes, or engineering, or whatever the case may be. It's something that you're ready to start with, and you've heard that there's this issue of entities. Perhaps you've been asked how you're going to set up your business, and you don't know the answer to it. Well, there are two major issues that are affected by and affect what entity structure you should be using, and those issues are liability and taxes. These are the two primary drivers, the two primary characteristics that are addressed by entities, and are the drivers of, ultimately the drivers of entity selection in combination with the facts and circumstances that impact your business. So let's take taxes first. For an example, let's just say that you go to your tax advisor and your tax returns have been filed and you owe $10,000. But your tax advisor tells you to write an additional check for $10,000. And you say, well, why would I do that? And their response is, well, you've done very well, you have the money, and why not help out the government a little bit? Give them a little extra. Well, of course, you probably would not feel comfortable with doing that, and you would probably feel like it's ridiculous. And yet, this is exactly what could happen with the double tax, which you've probably heard about, or you may have heard about. Now, this doesn't literally mean that whatever the tax is that you owe, that you multiply that by 2 and then you have to pay that additional amount. But what it does mean is that you can be legally obligated to pay tax on the same money twice. And we're going to talk about that more later on in this presentation. But just keep this in mind, the double tax. The second thing is, remember I mentioned two major issues that are addressed through entity structure. The second is liability. Let me give you an example of this. Let's say that you're doing business in your own name. You hang a shingle, you don't worry about entities at all, and You're very happy with what you've done. After 5 years, you've been very profitable and you've been able to put away $500,000 in the bank, $500,000. And you're about to go, and you've been in business for 5 years, you're about to go into your 6th year, and you get a call and find out that one of your customers has been seriously hurt at your business and is paralyzed. They sue your business for $5 million and they win. And they then seek to collect the money. Well, you've got a policy of $2 million, a liability policy, and that gets applied to this judgment. But now there's the other $3 million. And they come after the bank account with the $500,000 of all your profits in it. Every bit of profit you've made since you started the company 5 years previously. They seize it, they take it, it's gone. So all of your hard work is gone. And what's worse is only $2,500,000 of that $5 million judgment has been satisfied. There's still another $2.5 million out there. So now they start coming after your personal assets. They come after your bank accounts. They come after your vacation home or your rental property. Every asset they can find that they can legally attach, they do, and they take it to the extent of the law. And all of this can be avoided if you had just set up a proper entity structure. So this is liability. This is the thing that we are going to protect against through entities. So this is liability and taxes. All right. So let's move forward and get into a little more of the details. So the scenario that I just mentioned was one where your business was not set up as an entity at all. You were doing business in your own name. That is called a sole proprietorship. And a sole proprietorship means that there's one owner, which would just be you, the owner, and it is created by default. You don't need to do anything to be a sole proprietor. You just need to be in business and you are automatically a sole proprietor. And you have unlimited liability. And that is the reason that you lose all of the money that the company has made, and you start losing the assets that you have that are completely unrelated to the business, because you are the business and the business is you. There's no distinction, no separation between the two. This is the big problem with not having an entity. And this is what's called unlimited liability. Now, remember, there's always two major issues that the entity discussion addresses, and the other was taxes. So how are taxes handled if you are a sole proprietorship? Well, taxes are handled as what's called a pass-through. We'll in the next couple of entities we talk about, we'll talk about pass-throughs. But for now, all you need to know is that your sole proprietorship does not pay taxes on its own. You pay the taxes for the business, because again, there's no distinction between the business and you. You're one and the same. So the profits and losses of the business are reported on your own tax returns. The good news is that you're not worried about this double tax issue that I mentioned before. That'll come up later. So let's talk about the partnership now. The partnership is basically the same as the sole proprietorship to the extent of unlimited liability. It simply means that instead of there just being one owner, there are two or more owners. So if you are doing business with somebody else and you're doing business for the purpose of obviously making money, it is deemed that you are a partnership. Now, the reason I hesitate there is because you can have a formal partnership where you actually set up a partnership agreement and everybody agrees to how the business is going to be run, etc., and it's very intentional. But you can have what's called an unwritten partnership. And what that means is that you're doing business with somebody, you have no intention of them being a partner, but because of the facts surrounding how you do business, the law can impose upon you a status of partnership, which can be a bigger problem than it sounds. And I'm going to tell you why. The unlimited liability. Remember, we've got that same problem with the partnership. But the way liability works in a partnership, each partner is 100% liable for the entire liability of the business. It's not, that liability is not split according to ownership. So if you are a 50-50 owner with a partner and you get hit with the lawsuit I described previously, it doesn't mean that each of you has to pay half of that judgment. It means that you're each 100% liable for the entire judgment, which means that if one partner never saved a penny and they spent all the money that they made in the business, and you were the prudent one and you decided that you were going to save, and that's the reason why you have the $500,000 in the bank, it means that the entire judgment can be satisfied through you alone, or at least attempted to be satisfied. They can take everything you have because you're the one with the assets, and the other partner doesn't have to pay a penny because they have no assets. Is that fair? Of course it's not fair, but that's the way the law works. It's not based on the percentage of ownership. So this is a very dangerous structure to be in. There's one thing that makes this worse, if you can imagine it being worse. Remember I said that the law can impose upon you a status of partnership even if you don't intend to. Well, if there's a certain person or a partner, let's just say that you're working with, but they have partnership status because the law imposes this upon you, not because you've selected them as a partner. And they have done something that was the cause of this liability, the cause of this customer's paralysis, and you had nothing to do with it. You didn't even know that they were doing the thing that they did. If the law considers them to be a partner, then the same is true. You could end up having to satisfy the entire judgment yourself without a dollar being sought from the other partner, because that other partner may not have a dollar. The point is, you don't ever want to be in this situation. So let's move on to the next option, which is the limited partnership. The limited partnership is like a partnership, except you have two different classes of partners. You have the general partner and you have limited partners. The general partner is in control, is in management and control over the business operations, the decision-making regarding the business. The limited partners have no control. They're essentially what's called silent partners. And because of this, the law says that the general partner should be liable for the debts and the liabilities of the business. And those general partners have unlimited liability, just like the partnerships that we just talked about, the sole proprietorship and the partnership we just talked about. The limited partners have no liability. The liability of the company does not flow to the limited partners. So this is a huge improvement over the general partnership status that we talked about before. So, and I'll just side note to say that the partnership we talked about before, that's not the limited partnership, it's just a partnership. Sometimes you'll hear that referred to as a general partnership, as distinguished from a limited partnership. Now, with a limited partnership, you do have to actively do something with the state. Usually the Secretary of State's office, and it is a formal structure that you actually set up, where the limited partner, where the partnership, just like the sole proprietorship, happens by default if you are working with more than one person. So with the limited partnership, let's talk for a moment about taxes. So remember, there's always two issues, liability and taxes. So how are limited partnerships taxed? limited partnerships are taxed on the individual partner's personal tax returns, just like the partnership. So there's no difference there. Okay, so let's move on to the corporation. Now, here's where it starts to get a little more interesting, or maybe I should say differently interesting. So the corporation is a great kind of divergence from what we've been talking about. Everything so far has been a form of partnership. Now, the corporation is also formed through the state. It's not something that can happen by default. You have to be intentional. It's usually through the Secretary of State's office. And the owners of a corporation are called shareholders. And liability for the owners of a corporation, for the shareholders, does not pass from the company to the shareholders. So the shareholders are insulated from liability. Now, this is a great feature of the corporation. And we're talking about all owners. There's no distinction among shareholders as to who may be liable or not. There's a complete wall that insulates shareholders from liability. All right, so let's talk about taxes for corporations. With taxes, corporations are considered a completely separate tax-paying entity from the shareholders. So they are their own person for tax purposes, which means they file their own tax returns and pay taxes on profits and losses of the business. But the problem is, you as an owner, if you want to get money out of the business, because obviously you're in this for the purpose of making money, you have not gotten the money yet. In order to get the money out of the business, when you receive the money, you then also have to pay taxes on that money. It's the money that has already been taxed by the corporation, or through the corporation by the IRS. So there's the corporate level tax, and now you're being taxed again on the same money. This is the double tax that I started this presentation talking about. And as I mentioned before, it is not double in the sense of literally two times the amount of tax owed on the corporate level, but it does mean that the tax is being imposed twice. And there are many factors that determine what that tax is, tax rates, and the entire tax picture of both the corporation as well as your personal circumstances. But the point is, the money is taxed twice. And there are ways that your tax professionals can help to minimize that, or possibly even eliminate it legally. But if you don't have to deal with this issue at all, then it might be an idea to explore it. So how do we do that? Well, there's another entity called an S corporation, which seeks to do just that. An S corporation it's basically the same corporation that we've already been talking about. The only difference is that the S corporation makes an election to the IRS to say, hey, I'm a corporation, but I want to be taxed like a partnership. And it means then that all the tax flows through or passes through the corporate level to your personal tax returns. And they call that a pass-through structure. And S corporation is a pass-through entity. So now things are starting to look a lot better, because now we've got the liability protection of a corporation, but yet we've eliminated the double tax of the corporation. But there's a catch. And the catch is that S corporations are very rigid. There are a number of rules regarding how you can operate your business, structure your business, the type of capital that investors you can have for capital raising, etc. That can be problematic. For example, if you were to want to raise capital from, let's say you've got relationships with a couple of other entrepreneurs and they've got some extra cash and they want to invest as a shareholder in your company, in your S corporation, well, you can't do that, because S corporations generally only allow people to be shareholders, not other businesses. So that's a bit of a problem. In addition to that, institutional investors like venture capital funds will not invest in an S corporation. They generally are looking for you to be a regular corporation. Regular corporations, by the way, are sometimes referred to as C corporations. It just simply means it's not an S corporation. So these are some of the drawbacks of an S corporation. Let's see what we can do to improve upon the S corporation. Let's look at the limited liability company, or LLC. An LLC is, compared to the others, is a relatively new entity structure, but it's been around for for decades now. So it's very well established, and it really seeks to resolve some of these dilemmas. The members of an LLC are called, the owners of an LLC are called members, as opposed to shareholders in a corporation. And an LLC is formed through the state. It is typically the Secretary of State's office, and you can be a single member LLC in many states, but some states require you to have at least 2 members. Liability. Well, the liability of an LLC does not pass to the owners. So that means we're basically looking at the exact same benefit as a corporation. All members are insulated from the business's liabilities. What about taxes? There's also no double tax with an LLC because an LLC is a pass-through entity, just like the S corporation. So far, so good. We're looking a lot like an S corporation right now, which is great. However, one of the upsides, one of the benefits of an LLC is that it is very flexible on structure. All of the most of the rigid rules that you have with an S corporation do not exist in an LLC. An LLC is governed by an operating agreement, which is very flexible. The owners can really structure an operating agreement any way they want to. There's no restriction, as opposed to the bylaws of a corporation, like an S corporation or C corporation, is driven by statute, and it has to look a certain way and have certain attributes to it. An operating agreement, not so. You can pretty much do what you want to do with an operating agreement. And also, there are no restrictions on the type of members that you can have. You can have corporate members, and the flexibility of foreign investors. So this opens you up to a much larger pool of investors than an S corporation, where you could never have corporate investors or foreign investors. The one downside that is also the same as an S corporation is that institutional investors generally want to see a C corporation, not an LLC. And so if you're planning on using venture capital, an LLC is probably not going to work for you. But the fact that you've got so many other investor options by having corporations as investors, as members of your LLC, it really has resolved most of the issues relating to entity selection, the downsides of the other structures. In fact, LLCs have really become sort of the entity of choice, especially for small businesses and even larger businesses, for a lot of the reasons that we just talked about here. Now, one other thing I should mention is that with all of these entities, it is very important that you adhere to the formalities of the entity. So what do I mean by that? The biggest issue here is liability. The protection that you have by your entity that insulates you from the liabilities of the corporation or the liabilities of the LLC or a limited partnership, whatever structure you have, is because there's this notion that the business is a distinct being, a distinct party from you as the owner. And if you start blurring the lines between the business and yourself, then you can run into a problem where courts have oftentimes disregarded your entity and said, okay, even though you are an entity, you're not acting like an entity. You're not acting like a corporation. You're not acting like an LLC. You are commingling funds. You are using the company's bank accounts as your own bank account to pay personal bills, and vice versa. You're using your personal accounts to pay corporate bills. You're not having your annual meetings. You're not following what your organizational documents say that you should be following. And when you do this, the corporation, the LLC, the limited partnership can be disregarded, and all the liabilities will flow through to you, and it completely defeats the purpose of having that liability protection. So this is that, in that sort of closing thought, that is something that you and your professional advisors need to talk about to make sure that you as the business owner are following the rules and the formalities of having a business entity established. All right. Well, hopefully this has given you an overview of what the issues are for determining entity. And at this point, I will now turn it over to Michael Buchsbaum at Citi Trends for the next exciting topic. Thank you.
Very happy to be here today to talk to you about contracts. You'll see that I'm going to encourage you to be an educated consumer. So let's start with, who am I and what are my qualifications to talk to you about contracts? I'm a lawyer currently working in-house at Citi Trends for the past 11 years. I spent some time representing a company that owns hundreds of shopping centers. Before that, I worked at giant food supermarkets in Washington, D.C. Before that, I was in private practice for a few years. If you add it all up, that's 35 years of seeing and negotiating a lot of contracts. Everything from leases to IT contracts to vendor contracts to you name it. So the goal of this session is not to give you a complete overview of contracts. That would take much longer than the time we have today, and frankly, it would be very boring. The goal is to give you a practical perspective on what to consider on some important contract provisions and an approach to negotiation. While we're talking about these provisions, I'd like you to think about two kinds of contracts. Contracts where you're the buyer and contracts where you're the seller, because your position and goals are going to be different for each kind of contract. Where you're the buyer, you may be dealing with a supplier, or you may be getting some services of some kind. Your primary concern is the quality of the goods and services you're contracting for, and your primary obligation is to pay for these services. You want to ensure that you get what you pay for. Where you're the seller, the shoe's on the other foot. You're responsible for the quality of the goods, and your primary concern is to get paid for those goods. So there are 4 contract points you always want to keep in mind. The first is scope. By scope, I mean, what is the other party doing for you, or what are you doing for the other party? You want to be specific. You don't want to leave it to be agreed upon later. Why? Because you and the vendor may not have the same scope in mind when you get into the details, and you'll never have as much negotiating power as before you sign the contract. You'll want to talk about and think about, are there minimums? Is it an exclusive arrangement? If it's a new business relationship, you may want to test it out. Consider doing a small pilot and seeing what happens. There's nothing wrong with dating first before you get married. Second big contract point, money. What will it cost? Be specific. Don't deal in estimates. Don't leave it to be agreed upon later. You don't want to be surprised. If you're buying, do you want volume discounts if you buy a lot? Third contract point, time. What is the length of the agreement? What are the deadlines? Are there consequences for the other party if they don't meet the deadline? Do you want options to extend if things go well? If they're paying you, do you want the ability to increase prices over time? All right, well, you thought about these 3 items. What's the 4th item? Well, the 4th is liability. And that is, who's responsible if things go wrong? And for an important contract, that's one reason you want to get a lawyer involved. Well, you might say, Mike, I'm listening to you, so I don't need a lawyer. Well, there's a few important reasons to get one and some cost-effective ways to involve one. And here are the reasons to get a lawyer. Contracts have too many what-ifs and too much technical language, such that if you're not working with them every day, it's hard to know the consequences. Another reason is that entrepreneurs are typically optimists who are focused on the positive and are not thinking about what happens if a contract goes bad. A lawyer balances that perspective. Another reason is a lawyer can act as the bad guy, allowing you to preserve your business relationship. For example, you can say, I'd like to say yes, but my lawyer says I shouldn't. As a lawyer, I'm a professional bad guy. I know lawyers are very expensive and small businesses don't have a lot of free cash. So how do you navigate that? Well, there's a tradition in the legal profession called pro bono, which essentially means giving back by providing free legal services. Contact the legal aid organizations or bar association in your city and see if they'll connect you with a law firm. Law schools also have legal services provided by students and supervised by an experienced member of the faculty. I participated in one when I was a law student. It was a great program. As entrepreneurs, you're proactive by nature, so I'd encourage you to be proactive in getting a legal resource as well. And when you are getting your lawyer in place, think about these things. These days, lawyers are specialists, so to the extent possible, get a lawyer who has some experience in working on the kind of contract you have in mind. A good lawyer will be responsive, answer your questions, and help you consider issues. It should be a collaboration between you and your lawyer. All of the things we've talked about earlier, scope, time, money, these are business issues that you'll need to provide to the lawyer. You really can't delegate them. So let's now talk about the other big topic for today, negotiation. Most people either think of themselves as great negotiators or hate what feels like confrontation and avoid negotiation. I believe effective negotiation is a lifelong learning process and it does not have to be confrontational. When you think about it, we all negotiate every day. Whether we're talking to a credit card company about an incorrect charge, talking to our partner about where to go for dinner, or talking to our kids about when to go to bed, it's a negotiation. So it's really familiar to all of us. As a young lawyer, I was faced with the question, how should I negotiate? I went to law school, read a lot of cases, learned a lot of laws, but wasn't trained there as a negotiator. My initial approach was, whoever has the leverage wins. Whoever needs the other side less has the advantage, and you just push until you get what you want. I think a lot of people approach negotiation that way. The question of leverage is always in the background, but it has many disadvantages. First, if you're not the one with the leverage, you don't have an effective negotiating strategy. Small businesses often don't have the leverage. And then second, it's highly confrontational and leaves a bad taste in the mouth of the party you want to build a business relation with to negotiate purely from leverage. The reality is that in most negotiations, both parties want the deal and neither party has the leverage to dictate terms to the other. So what do you do instead? Here's another approach. Back when I was grappling with this question, a senior lawyer I worked with recommended that I read a book called Getting to Yes that was written by a couple of Harvard professors. That book changed my entire perspective on negotiation. It encourages you to think of negotiation as a joint problem-solving session. When one party says no on an issue, that's not the end of the discussion on the issue, but the beginning. If you can find out why they're saying no, you may be able to solve what they're concerned about and get them to yes. This helps you view issues from the other party's perspective. For example, a landlord may say, well, you can't load and unload on the west side of the building you're leasing. You may need to take deliveries there. So you can ask them what they're concerned about. The answer may be that they've had neighborhood noise complaints due to loading late at night and in the early morning hours. You may be able to agree to take your deliveries during regular business hours and your problem's solved. Many issues come out of a recent bad experience that the party has had with somebody else. You may be able to show them that you have the issue covered, and it may not be an issue at all. I've used this approach countless times in negotiation. I'm sure there are other books out there with great advice on negotiation, but for me, this is the one that works. By the way, it's a quick read and about $15 in paperback. I don't own stock in the company that publishes it, so I have no reason to recommend it, other than it's been incredibly useful to me. So what are the limitations of this approach? Every approach has limitations. Well, the first is if the other side is determined to negotiate on the basis of leverage alone, There's little you can do to change that. I find this is rare, because remember, you're always dealing with people, and people don't like to feel like they're being unreasonable. Another issue can be if the other side doesn't engage in the process in good faith and negotiates by such practices as hiding the ball, wearing you down, threatening to walk away from the deal. There's a companion book on how to deal with those kinds of people called Getting Past No, but I'll suggest that you may want to question whether to enter into a contract with somebody who negotiates that way, because it's not likely to get better after you sign the contract. So what other negotiation tips can I give you? Do your homework on the company and even the person you'll be negotiating with. People like when you know something about their business, and I'll often look up a lawyer I'm going to be negotiating with online. Bear in mind that LinkedIn shows viewers, and you may turn up in someone's Facebook feed if you look them up. So if you don't want that to happen, use other sources. A few minutes of small talk before you begin a negotiation helps break the ice and gives each person a feel for the other. Making a human connection helps. Try to read your audience in this regard. You may even throw something in like you've seen that they've worked in the same city that you have, but do that in small doses. Try to talk about some items first that are easier to reach agreement on. This builds rapport, shows each side the other can be agreeable, and creates a positive atmosphere. There's nothing worse than getting into an argument on the first item. It really sets the wrong tone. If you get into a contentious item in a negotiation, sometimes a little humor can break the tension. Try to read your audience on this as well. What's funny to you may not be funny to them. Also, you can always table an issue and say you want to come back to it, or you need to talk to your partner. Issues can be easier to solve if they're the last open item and everything else is agreed upon. Also, on Zoom calls, we've all gotten used to dogs, cats, and children making their way into the picture. You can see these human moments as an opportunity to build rapport. Now, I'd suggest you should always know what your BATNA is. Now, what's BATNA? BATNA is the best alternative to a negotiated agreement. It's basically your plan B. At some point, your plan B may start looking better than your plan A. If you don't have a plan B, you may have to fold on some issues if you can't work through them with the other party. Particularly when you're a buyer of services, remember that sales reps make their living on the basis of their verbal skills and pleasant personalities, and are not necessarily going to be providing the services or even involved in any way once you sign up. If you feel it's warranted, try to have the vendor include someone from the actual service group in your conversation. You may be surprised by what you hear, particularly with regard to the ease or difficulty with which the services can be provided and how long it will take for them to be put into place. The best deals with service vendors are often cut towards the end of the year when the sales rep is trying to make his or her quota for a larger bonus. If the sales rep won't put an item in a contract, don't count on receiving it. Almost all contracts have a provision stating that prior conversations and documents have no effect and are superseded by the written contract. Now, you've all heard the age-old adage, if it sounds too good to be true, it probably is too good to be true. I found that to be correct. Your common sense is your best friend. The sales rep is not a neutral advisor looking out for you. Their goal is to get you to sign the contract. If there's something in a contract you don't like, don't accept the answer, it's a standard contract, or it's standard for the industry. Many of these contracts are created by trade associations for their members and are slanted towards protecting them. Also, the answer, well, it's not our policy. It's not a good reason for a provision in a contract. Some parties will tell you that they don't negotiate their contracts, and in some cases that's true, but more often, even parties that say that initially will negotiate at least a few provisions that are important to you. If you have doubts about a vendor, don't proceed anyway thinking, well, I have a contract, so if it doesn't work out, I'll just sue. If you think having a lawyer review a contract is expensive, the legal costs of enforcing a contract add up quickly, and it's a slow and uncertain process. You need to have the legal rights in the contract because the other party won't want to run up those costs either in the event of a dispute. But given the drain on your time, money, and energy, a lawsuit is a last resort. If the vendor is sketchy, sometimes the best contract is the one you don't sign. So at the end of your negotiation session, there are often things each side has to do, like talk to their management, get more information, draft some wording. It's helpful to recap what each side is going to do and set a date for a follow-up, as people will work to meet a fixed deadline. At the end of the day in a negotiation, you and the other party may not have common interests, but you're working towards a common goal. It's good to periodically bring the conversation back to that. So what I want you all to leave here today thinking about: scope, money, time, liability. Lawyers have a role. Treat your negotiations as a joint problem-solving session if you can. And don't believe everything you hear from sales reps. Thank you. All of us here at the Small Business Academy are rooting for you.
Thank you for joining us for this session of the CITIcares Small Business Academy. This presentation has been prepared by Citi Trends and Seyfarth Shaw for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. Please leave any questions or feedback in the comments section below. For more helpful links and more episodes, please visit the CITIcares Small Business Academy YouTube channel.